Hello, friends. Welcome to another discussion of the Hindu editorial. Okay, so today's editorial holds immense importance for us because of the prelims examination as well as the mains examination previous year question. If you see, okay, so you will find that this higher judiciary has been one of the favorite topics for the UPSC. Okay, so the title of today's editorial is Judicial Review: Tough Law with a Loophole. Okay, so it has been written by a prominent writer, PDT Acharya, who is a former Secretary General of the Lok Sabha. Now, what has happened is that the 107 members of parliament in the Lok Sabha, which is basically all of them are from India bloc, which is a opposition party in India, having given a notice of an impeachment motion in December 2025, seeking the removal of Justice G.R. Swaminathan, a judge of the Madras High Court. Okay, so 107 members of parliament have submitted impeachment motion demanding the removal of G.R. Swaminathan, who is a judge of the Madras High Court. So this motion contains 13 charges, and two of them are acting against secular constitutional principles, and also second one is favoring lawyers of particular community. Okay, and this notice of motion was submitted to the Speaker of the Lok Sabha, Om Birla, on December 9. Now, what are the terms and conditions with regard to the removal of the judges? Let us see. So, terms and condition. So, impeachment of a judge of the Supreme Court of India is provided for in Articles 124. So, impeachment. So, impeachment. You see, impeachment of a judge of the Supreme Court of India is provided for in Article 124, Clause 4, and 124, Clause 5 of the Constitution, and that the High Court and that of the High Court judge is in Article 217 1, Clause 1 and Subclause B, and 218. Okay, so the term impeachment is not used in the Constitution, which instead uses the term removal in the case of judges. Okay, the term impeachment is used only in the context of the removal of the President of India from his office. So basically, this here to here, what these lines is trying to say is that the impeachment of the judge of the Supreme Court is provided in under Articles 124, part subclause 4, and Article 124 clause 5. Okay, and the impeachment of the judge of the High Court is basically given in Article 217, Clause 1, Subclause B, and 218. And also, it is saying that the impeachment is not in the is used in the Constitution, which instead uses the term removal in the case of judges. Okay, so if you want to remove the judge, then the Constitution use the term removal, not the impeachment. Please remember one thing. This is the one of the important fact. And impeachment word is only used in the context of the removal of the judges from his office. Okay, and Article 61. The procedure laid down in Article 124 for the removal of a Supreme Court judge applies to High Court judge as well. So it means that the all the procedure which is follow to remove a judge of the Supreme Court under Article 124 will be applied to the removal process of a High Court judge as well. Okay, so there is a no difference between these two process of removal of the High Court and Supreme Court. Okay, judge, sorry. Yes. Then Article 124, Clause 5 provides that Parliament may make law to regulate the procedure for the investigation of the charges against the judge. So Constitution has not provided how you are going to regulate the procedure for the investigation of the charges against the judge. Okay, what the Constitution provides? The Constitution provides that how what are the steps that you should follow. Okay, so Articles 124(5) provides that a Parliament may make law to regulate the procedure for the investigation of the charges against the judge. So accordingly, Parliament enacted the Judges Inquiry Act in 1968, which together with the judges inquiry rules deals with the entire procedure for the impeachment of the judges. Okay, so entire procedure of the impeachment of the judges are given in under Judges Inquiry Act in 1968. Okay, so if you see the previous question, I think two questions in last 10 years have been asked from this Judges Inquiry Act 1968. Okay, now a judge of the Supreme Court or the High Court can be removed from office on the ground of proved misbehavior or incapacity. Okay, so what are the ground for removing a judge of the Supreme Court or High Court? So these are two, only two: proved misbehavior or incapacity. Okay, however, the misbehavior has not been specifically defined in the Constitution, but the court has in number of judgment explained this term as conduct which brings dishonor to the judiciary, willful misconduct, corruption, a lack of integrity, offense involving moral turpitude, and willful abuse of judicial office. Okay, so only two ground are laid down for the removal: proved misbehavior or incapacity, which have not been uh, defined in the Constitution. However, court has in number of judgments explain what these two terms means. Now there are a few judgment, you can read these things to understand the what does this mean. Okay, proved misbehavior and incapacity. Now let us see other things. So now we'll discuss about the procedures of the motion. Okay, now what is the procedures of the motion? So an analysis of Article 124, Clause 4 and Clause 5 and Judges Inquiry Act 168 and rules would reveal that the lawmakers were extremely careful about protecting the independence of judiciary. So the law relating to the removal of a judge of the superior courts was made as tough as possible. The main provisions of Article 124, Clause 4 and Clause 5 are: an address to be passed by each House of Parliament supported by a majority of the total membership of each House and by a majority of not less than two-thirds of members who present and voting, who shall be sent to the President seeking the removal of the judge, who shall thereupon pass an order removing the judge from his office. I know that you are not able to understand, so let me make it simple. Okay, let me simplify it. Okay, so this much thing we need to understand very well. Okay, okay, so let me use another thing. So the so what is it is saying that the an address to be passed by each House of Parliament supported by a majority of total membership of the each houses of house and by a majority of not less than two-thirds of the members present and voting, which shall be sent to the president seeking the removal of judge, or who shall thereupon pass an order removing the judge. So when motion is admitted, when motion a motion for the removal of judge of the High Court or Supreme Court is admitted, then what happens that an address to passed an address to be passed by each House of Parliament supported by majority of the total membership of each house. Suppose total membership total majority of a total membership of each house, which means that if suppose there is 100 members, total membership of Lok Sabha is 543. Okay, so there is a 543, so the majority of total membership means majority of 543, okay, of the Lok Sabha, and 250 majority of 250 of the total, that is the total membership of the Rajya Sabha. That majority of the Rajya Sabha will and along with by a majority of not less than two-thirds of member present. And how much members are present they on the day of the motion. Okay, so motion being admitted, then the just a minute. So, by a majority of not less than two-thirds of the members of the present and voting, which shall be sent to the president seeking to. So, two types of majority is there. So, both are the special majority. One is the effective majority, and second one is the special majority. Okay. So, what is required is that the when the motion is motion for the impeachment of the judge is brought to the parliament, then each house has to pass that motion by majority of their total membership. Okay, so majority of total membership means total number of seats of a particular house, the majority of the total membership of that particular house. Okay, so 545 you need to have the majority of the to 545. Okay, so 50% of 545, then total member present, you need suppose out of 545 200 members have present on that day. Okay, so so you need to have majority of 200. Okay, so 100, 50% of 200 means 100 or 101. Okay, so with that effect you need to pass it 40%. Okay, then president will give the assent. Okay, so that is how it happens, and the act provides for a motion to be submitted to either house to the speaker, Lok Sabha, or the chairman Rajya Sabha, signed by members of either house. Okay, so you can the motion can be submitted to any house, Lok Sabha or the Rajya Sabha. It requires not less than 100 members of the Lok Sabha to sign the notice of the motion if given to the speaker, and not less than 50 members of the Rajya Sabha to be signed to the notice if given. Now, a speaker and chairman may disallow or can allow it. Okay, so it is pure discretionary or discretionary power on them. That is, so you can see he now the this if they are not admitting this motion, then it can be challenged in the Supreme Court as well. Okay, challenge in the court as well. So what is the flaw? So flaw is that the reason for not allowing or disallowing the motion is not given in the procedure in the law. Okay, so it is on the chairman or the speaker to whether to allow the motion or not. Okay, so that is the thing. So no ground, you see here, no ground on which motion signed by as many as 100 members of parliament can be rejected at the threshold. So that is the biggest loophole. So thank you very much. I hope you understood. Okay, so that's all for today.